Do you know someone in foster care? Have you been in foster care? Do you have a child in foster care? Are you a grandparent or relative caring for a family member? Are you considering becoming a foster parent? Then tune in every Wednesday at 3 p.m. to Fresh Start Today on WNOV 860 AM to engage in thought-provoking conversations with families and providers about child welfare services, both locally and nationally. Together, we can save our children. Good afternoon. You're listening to Fresh Start Today. I'm your host, Jermaine Reed, and it is a lovely day outside. The season is changing. Today is October the 21st, and it's 3:03 in the afternoon. And we have Sean Roby, co-host in the studio with us today, and a special guest, which is attorney John Lamadola.
Yes, sir.
John Lamadola. Great to have him here today. We're going to be talking about a very interesting topic in our In the Courtroom segment today. In the Courtroom will be taking the place of our Ask the Judge segment, just because there's a lot of players who are involved in court proceedings, and we definitely want to be able to have an opportunity for a number of folks to come in to educate the community about court proceedings. And so today we have Attorney John Lamadola, and we are going to be talking about understanding termination of parental rights and the jury trial system. Very important. So listen, if you know someone, or perhaps yourself, you've had a child removed from your care recently within the last couple of days, we definitely want you to sit down and get a pen and tune into this show, and feel free to call in at the appropriate time, 414-444-5250. Or if something happens in the future, you can be armed with this information, this knowledge in terms of what your response can be in dealing with child welfare, as well as with the court system, juvenile court system. And I just want to say as a disclaimer here that Attorney John Lamadola will not be providing any legal advice or anything like that, but he definitely will be expounding on some things like what is the termination of parental rights, what is AFSA, Adoption Safe Family Act, and how does that impact reunification, family preservation and reunification. We will be talking about adoption, the pros and cons of all of that. But particularly there's an element of the whole court process called jury trials, and most folk don't know anything about that, but there is a particular time when that needs to be done in your case, and what are the pros and cons of the jury trial system. So listen, we want you to tune in, and so welcome. Good afternoon, attorney.
Well, good afternoon to you and Mr. Roby and your listeners today.
Oh, that's great. We're so glad to have you in today. This is a
good to be here.
Very important topic, as you might can imagine. Can you talk a little bit about yourself? What area of law you represent, and what are some of your favorite cases or types of cases to represent? And
well, the primary focus I've been in private practice since 1997. The primary focus has been in mostly defense work. I've done other work related to real estate and some other issues surrounding personal injury cases and so forth. But the majority of it has really been dedicated to cases involving criminal defense, cases such as this, cases involving Child Protective Services actions, and termination of parental rights cases, delinquencies and juvenile cases. And in the Child Protective Services and termination of parental rights cases, primarily as an adversary counsel, that would be a defense attorney for parents. But I've also fulfilled the role of a guardian ad litem in a lot of cases too. So I've also had the pleasure of working on it from the interests of the child and representing those.
Okay, so you said adversary counsel?
Adversary
counsel.
counsel.
No, why they call it adversary counsel? Because we all supposed to try to get along in the courtroom. Why they call it adversarial counsel?
Well, it certainly is an adversarial system. I think in these cases, being that they're civil, we're technically called respondents. Parents would be respondents in actions. The state would be a plaintiff, whereas in a defense criminal type action, we're sort of the client is called a defendant, so there's a little bit of a distinction. So I think in that sense, the attorney's role is, rather than defense attorney, I should say an adversary attorney. Okay.
Well, you know what? We're going to talk about these children court center cases, or CHIP cases, child welfare cases, some of the same terminology. But the 14th Amendment to the United States Constitution has language that speaks to or provides the basis or grounds for individual citizens to raise their children with at least amount of interference from the government, unless, and again, that's the key word, unless there's some harm or there's something going on where there's a high risk that impairs that person's safety or their well-being. Then in those cases, government agencies can come in to protect the young citizens, which happen to be children in these cases. Do you agree that that is correct and accurate?
Right. I would say, there's a competing interests.
Okay.
There are the compelling state interests of protecting children. The courts and the Supreme Court have recognized that children have a right to be protected, to be healthy and safe, and that is sort of opposed to the rights that a parent has as a fundamental right to be able to properly raise their child. And as you noted, of course, yes, under the 14th Amendment, the right to protect life, liberty, and property, we've sort of assumed that into that group so that they're entitled to certain procedures and certain processes to help protect those.
So parents have constitutional rights,
Yes.
and children also have the right to be protected.
Exactly.
Okay, and which is interesting because I think when the Constitution was originally written, children probably were not regarded as children, but more so as property.
Interestingly enough, until late 1800s, early 1900s, the child welfare system, as we know it, was non-existent. I think
Correct.
there was an assumption that parents took care of their children. It wasn't until a few cases came around we started to develop that. And really in 1970, I believe it was 1977, but there was a major amendment and some actions taken by the government that basically set in motion the system as we know it today.
Okay.
With the child welfare system. And there have been obviously some changes and modifications along the way, but you're absolutely right. I would agree with that.
Okay, so now for those callers who are just tuning in, you're listening to Fresh Start Today on WNOV 860 The Voice. I'm your host, Jermaine Reed, along with co-host Sean Roby, and our guest attorney today is Attorney John Lamadola, and we're talking about understanding termination of parental rights and the jury trial system in Wisconsin, particularly in children court or CHIPS cases. And the question that I have for you, we talked about this 14th Amendment, the fundamental right or liberty for folks to raise their children without interference from the government, but of course there are some grounds or some situations where the government need to come in. The child welfare system today is not necessarily the child welfare system that was in place when the Constitution was written, and you have represented a number of plaintiffs. No, not plaintiffs. Respondents.
Respondents, exactly.
Who are parents who've had their children removed. And so, have you done a lot of those cases, or?
I have. I've committed, as I say, a majority of my practice, at least a portion, 50% of it at least. I've done a number of those for quite a few years, as early as the late 1999, I think it was, or 2000.
Okay, and so there's this I don't want to call it thing, process called termination of parental rights, and typically that comes up when any child is removed from their parents' homes. There was federal legislation passed in 1997 under President Bill Clinton's administration, referred to as the Adoption Safe Family Act, and those kind of go hand in hand. So we want to talk a little bit about what is termination of parental rights and what is that process like. So what is termination of parental rights? What does that mean?
So basically it's a filing. It usually is filed by the state. In Milwaukee County, it's actually an action that is started by the district attorney's office. In most other counties, it's a corporation counsel who actually files that. It's an attorney who works for the county under that division. There are also private termination of parental rights actions. So under certain circumstances, a parent or a relative or other could file a termination of parental rights action. But essentially it is what it really says, and that is that it is an action which seeks to permanently sever any legal parental relationship to that child.
That's important. Parental rights are important and need to be protected. And so there is a process here that if a child is in out-of-home care for 15 consecutive months out of 22 months, then the agency that removed that child, being representing the state, complying with federal guidelines, need to file a petition for that parent's rights to be terminated. And that is what we refer to as AFSA. So what is it that you think that we can share with this listening audience that's important to know about AFSA? Are there certain special considerations that perhaps need to be made? And folks really do need to write down that 15 out of 22 months.
That's very important. And that is from the day the child is actually removed.
From the day, very day.
Yeah,
there's a federal clock that starts ticking immediately.
That's right. So in many cases, while you may have a Child Protective Services case that's ongoing, you have to keep in mind that process can take a while to resolve and establish an ultimate order, which you're going to be required to comply with. So the more time that does pass, you have to realize that each day that goes by is a day that 15 months is passing by.
And so basically when folks get involved with child welfare, everything is time sensitive, and you've got to be on top of it from out the gate. You know, regardless of whether you have mental health issues, aorta issues, cognitive or intellectual disabilities. I mean, that clock is ticking, and folks just got to keep that in mind. But let's talk a little bit about. We mentioned that one of the grounds for agency filing petition is if a child has been in out-of-home care for 15 months out of 22, but also if a child is determined to be an abandoned infant as defined by state law. Then the other thing is if a parent has committed or been involved in murder, voluntary manslaughter, or felonious assault of one of his or her children. So those are three criteria or three bases for that state agencies can use to file for a TPR.
Certainly, and there are several others.
Okay.
What you note is correct. We do have also, yes, a period of 3 months or longer of an abandonment. So if you're under a CHIPS order or otherwise and you fail to have contact with your child or with the agency necessary to be able to facilitate some kind of a natural contact, that gives them a basis to file a termination of parental rights action. And unless you have good cause for not having, meaning a good reason for not having had contact, that could be a really tough situation. You may actually find yourself in a situation where you may not be able to defend that very well, and they can establish grounds on the TPR fairly easy.
And that's extremely important for a number of reasons, as you mentioned. But when you just think about a parent who may be suffering from some type of mental health issue or some substance abuse, and they may not be may not have a stationary home, and so they're transient and moving around, and if they're addicted to some substance, and they may not get letters, they may not know about court conditions that they have to meet, and so now you got all this going on, and as you mentioned, that clock is constantly ticking.
Listen, if you listen to this program and you'd like to join the conversation, you can call 414-444-5250, 414-444-5250. I'm glad you brought up abandoned because here I had quoted an abandoned infant, but we're talking about abandonment from the context, as you mentioned, not making contact, phone calls, and not. Well, that's really powerful because when I think of abandonment, I'm thinking that you just leave your kid on the side of the road but we're talking about how important it is to engage in services and engage with your child. So as an adversary counsel, representing a respondent, Attorney Lamandala, what is it that you need from clients?
Well, early on, and this goes back, it's interesting, you're doing a show on termination of parental rights cases. In Milwaukee, the majority of them obviously are related back to the Child Protective Service cases. The biggest piece of advice that I could give clients from the very beginning is to go through the legal process, and if you decide to have a trial or exercise rights in the underlying Child Protective Service cases, that's okay. But in the interim, you have to be actively involved to the extent the court allows you to do that. There are temporary orders in place and otherwise. And from the very beginning, you need to make yourself available for visitation. Consider with your attorney's advice which programs you might want to start preliminarily. Because
before they're ordered.
Before the order, because once the order's made, that is obviously, those are the ultimate decisions. But in the interim, people usually have a pretty good idea in this, what programs they think you should, after being assessed, what you should be participating.
But are these free programs or services, or is there a cost attached to them? Because if I start a program that's not court order, does child welfare or whomever have an obligation to pay for those services?
They usually will refer it on.
Okay.
If it's determined that you have independent insurance or otherwise, they obviously prefer to try to work with that process first to avoid any costs. But my experience has been in most cases, the majority of cases, we are usually dealing with the folks that need the referral and don't have the economic needs. I think that's rarely called into question. They're usually very proficient in getting referrals made if the client's willing to do that, and the Bureau has the resources, of course.
Now, there's some exceptions that can be applied to this situation in terms of the state agency filing a petition to have a parent's rights terminated. There are some exceptions. Can you talk about what some of those exceptions are?
You certainly. Obviously, if there is a compelling reason why it isn't in the child's best interest. Another might be the current situation with a kinship type placement or being placed with a relative, or in a situation where the child welfare agency has not provided the necessary reasonable efforts or the referrals and the follow-up and the subsequent services they're required to provide in a timely fashion.
So they have a case plan. They have a case plan.
That's right.
That's going to outline the conditions or things that you need to do in order to have your child reunified or to come back home.
For example, I think one of those might be AOTA counseling. And it sounds like if the case manager has not identified a particular counselor and it's taken 90 days or even more, so that's one of those exceptions that you're speaking of.
That's a very good example, actually. And there has been recently, we've seen high turnover in a couple of the agencies with frequent rotations. I don't know that necessarily has been something we've been successful in challenging, but it certainly does play into the factor of communication between the client and the parent and the worker, and the ability to make services occur sooner than later.
Now, let me talk about this. In 2006, researchers Lenore McVeigh and Tammy L. Henderson and Susan Tice released findings from a study that sought to identify how AFSA or Adoption Safe Family Act influences foster care outcomes of cases involving parents with psychiatric disabilities. Also examine trends in TPR decision of parents with psychiatric disabilities and explore the course account of how parental behaviors influence decisions to terminate parental rights and provide implication for family therapists. Now, what was interesting in this study is that they found that therapists either were not aware of the times concerned with AFSA or could not sufficiently treat clients within the federal timeline of 15 out of 22 months.
Wow.
The findings was demonstrated in part by therapists' own recommendations to courts, such as the parent needs 6 to 8 months of treatment before change can even begin to occur. Mothers need at least 2 years of therapy. So we're dealing with 22 months and 24 months, depending what those underlying traumatic issues or because drug abuse and drug use a lot of times is symptomatic. It's related to something a lot deeper than just, I don't want to take care of my kids. I don't want to feed my kids. I don't want to, or that I'm beating my kids. I have nothing else. Right. There's something deeper here. So if we have therapists who are saying, you know what, wow, addiction recovery is a process. That mental illness, depression is a process to recover from that. Parents have to deal with all of that while going to all kind of meetings, and you can't miss it. But hold on, we have JT, our friend, on the line. JT, good afternoon. You have a brief question or comment?
Yes, sir. Good afternoon, sir. How you doing?
I'm doing great, JT.
Okay, and good afternoon to your guests.
Yes.
Yes. Everybody and gentlemen, I've been hearing about this issue that's been going on with our community when it comes to our young kids, children being born in a hospital by their parents. It might be a drug or alcoholic person that don't get really treatment for it. They get locked up in jail or something like that because they did something wrong, trying to take care of that. That's one issue that you've been talking about and expanding on, and I appreciate that, gentlemen. However, what I would like to say, though, respectfully speaking, I have noticed that for some strange reason, when a parent do have those issues where they are having difficulties trying to survive and take care of their child.
Yes.
First of all, these days, when a parent has a child in a hospital, if the child still deemed to be healthy or whatever, that parent is sent away from the hospital and the child, in 3 days. I remember back in the days, excuse me for saying this respectfully, gentlemen, if you remember this, but it used to be about a week when a person gave birth to someone, a child. They check the child out thoroughly before they send them home and stuff like that.
Mm-hmm.
But that was like back in the 1960s, 70s or something like that, early 80s. But now it seems like when a parent have a child, they may have some issues. When they're in the hospital, they give birth to a child, they may have some issues. They are sent home. and then something happened to that child. They call it crib death, or they're trying to blame the parent for that. That's one way I'm trying to look at it.
All right.
However, I'm going to make it this quickly, and in conclusion, only thing I want to say is, gentlemen, I know what you said, and thank you for being there, but when it comes down to a child being taken away from the parent for whatever reason, they have other relatives that want to take on that child to take care of them, but they can't.
Okay.
Because they can't afford to, but they're not going to be paid for it like they would if they went to an adoption agency or whatever the case may be. Because they want to take care of that, and want to keep that child within the home,
Okay.
around their relatives and things like that. But they're not being compensated for that, to take care of that child, even though the parent might have some issues.
All right. Well, let me respond to that, JT, and I know we have another caller. But,
I'm sorry.
But foster care, I mean, relatives, there is kinship care. And we did have somebody on the show last week that started to touch bases on that. And you can call 344-1220 Kids Matter, because they do have a program, that really can assist relatives who are interested in providing care to their children or to their relatives. So my position, I agree with you, JT, is that I think Child Welfare America needs to reform or to reevaluate their efforts in preserving families, meaning dedicating, reallocating resources to families and support families like they support non-relatives.
Yes, sir.
Because we know from a data standpoint that children thrive and do better in their families of origin than in non-relative care. Thanks for calling, JT, and you have a great week.
Thank you.
Yes, Mrs. Adams, you're on Fresh Start today. Do you have a brief
Yes.
question, comment? Yes.
I agree with you on that too. Like years ago, like maybe in the 1950s, then maybe 60s, there was a doctor, I can't remember his name, who was complaining about saying that people shouldn't spank their kids.
Okay.
And so what started to happen is the laws started to go into that area and saying that they couldn't, that they had to be legally charged with stuff having to do with them, spanking their kids. And so they would take their kids away as a result of them whipping them, and what we used to call it whipping. And so, but this same doctor changed his mind later and said that he feels that maybe that's something that needs to be done a little bit or something. But the point is that that's when they started taking our kids away. You know what I'm saying? And so when they started taking our kids away because we were spanking them or whipping them, whatever we want to call it, that is when the problem started, in my opinion.
All right. Well, thanks a lot. Thank you, Ms. Adams. And we'll respond to that piece. Well, I would like to say, and Attorney John Lamandola, he can respond, but in Wisconsin, there's something called the Children's Code, Chapter 48. And Chapter 48, a lot of people don't want to talk about this, but it's on the books. It's in statutes. Parents have the right to physically discipline their children. However, there is a difference between disciplining your child and being abusive towards your child.
Correct.
And certainly there are some cases that come to the attention of child welfare, that come to the attention of relatives before child welfare gets involved, that present themselves that says, you know what, this is abusive. Mm-hmm. This is wrong. And something has to be done. There needs to be an intervention, and that is language that is supported in the Constitution. The other thing I want to say about this, because JT, our caller, he had brought up about children being taken away. To have a fair and balanced conversation, we also have to understand that there's a lot of parents who are voluntarily terminating their parental rights.
Correct.
There's a lot of children. I've worked with them personally in my home. Over the summer, had 3 young men whose parents contacted child welfare and said, I can't do it. I don't want them. So it's not just about child welfare coming in and snatching all of our kids, but it's folks who are throwing up their hands and saying, I can't do it for whatever reason. So, so those are conversations. We have to weave that into the conversation in order for it to be balanced. But go ahead.
And I think to take a step back, when you talk about parents having the right to physically discipline their children. We also have to keep in mind, as you mentioned, there's a difference when there's abuse, where there's marks and there's excessive force. That's when things are identified as abuse. So just wanted to, hone in a little bit on that. But then, as you mentioned in responding to JT, is where you also, when you talk about hospitals, and he mentioned years ago, babies would stay in there with their mothers for a week, but now it's only get them in and out for 2 days. You mentioned preventative measures. If we can provide more families with preventative measures on the front end, maybe we can prevent a lot of these unfortunate circumstances from occurring.
Attorney Lamandola, you have brought up how there must, according to AFSA or Adoption Safe Family Act guidelines, reasonable efforts must be made to preserve family ties, family preservation. What are reasonable efforts?
Reasonable efforts, when I refer to those in that context, typically they are actually court-ordered, and they're the services that the Child Welfare Agency has to provide to the parents so that they can accomplish the requirements, the goals, the conditions that have been set forth of return for the parents. And it's very important that they are diligent about that they make it themselves available, that they make the necessary referrals to accomplish those court-ordered requirements.
Okay, because something I was reading was stating, I believe it was the National Disability Council, or the National Council on Disability, I forget which way it goes, but that reasonable efforts are not defined in law or in federal regulations and have been interpreted in a wide variety of ways by states and the courts. And unfortunately, the vagueness of this term may cause some damaging effects on families and children, particularly when it comes down to preserving that family unit. Would you agree or disagree or add something?
Well, I think there's a couple of different aspects to reasonable efforts.
Okay.
During the process of reviewing the case in the CHIPS or Child Protective Services phase of it, attorneys can raise that issue and ask the court to make a finding that reasonable efforts have not been made. That can slow the TPR or adoption permanency planning. So that's one of the areas that if there are problems with reasonable efforts, they essentially can toll some of the time, because obviously the court would make a decision on that based on the facts put in front of it. At the second portion of it, in one of the allegations under the Termination of Parental Rights statute, under continuing need, where we talk about, one, has the parent met the conditions of return? If not, are they substantially likely to in 9 months from the date of that termination of parental rights trial? Two, has the Bureau or the Human Services Department provided the necessary reasonable efforts to meet that? So those are two of the requirements, and that basically would be an assessment made by either a judge or a jury in a termination of parental rights action to determine whether essentially they feel that those reasonable efforts had been made. So that's one of the elements that the state has to prove in that particular allegation of continuing need. So it's kind of it's maybe vague and amorphous, but it depends on circumstances, and each case probably varies.
There's some national organizations and groups who feel that, as for the Adoption Safe Family Act, that the spirit of it, in a sense, kind of moves folks away from family preservation and reunification, and the incentive is more toward adoption, or, as they say, permanency. And so I want to kind of talk about that, because what they talked about is that that it's reducing the focus on reunification, because it's allowing state workers and the court systems to move this case along a dual track, which typically, the permanency plan, when you go to court, they'll say, okay, well, we want to move toward reunification. We want to send this child home, but at the same time, we also want to be looking for an adoptive resource. So for individuals who are inundated with a lot of work, a lot of court appearances, a lot of folk on their cases, having that option or that door open to have a dual track, do you think, in your opinion, that that kind of prevents family reunification versus if it was just strictly a family reunification track and we're going to dedicate all of our resource and energy in trying to get this child back home with his birth family. What are your thoughts on that?
Well, it's pretty clear that the AFSA law puts in place this mandate.
Yeah.
And that obviously is where we get the dual planning, I think, to some extent, because what we need to do is we need to say, hey, if the parent is making sufficient progress or making some progress, but not enough because we're approaching that 15-month mark, we need to also have resources dedicated to looking for adoptive resource, to looking at that position. So both angles are pursued simultaneously. We used to have a primary and a secondary
Okay.
goal. Now they're concurrent, meaning
Okay.
they run at the same time. So much of this does have to do with the parent's overall progress. I have seen cases that have some age to them. They've been going on for a while, but because of the parent's progress, they still do at times order a sole goal of reunification. And sometimes in cases it's very early on and the judge will actually believe that adoption should be the plan because there isn't a lot of activity on the part of the parent. So it's very important that from the outset, as we were talking earlier, parents really engage themselves. This has to become a full-time sort of a full-time effort by them to really work hard because the time is short.
And, you know, in a full effort, because I've seen some cases, and, you know, I like to be very transparent and honest. I've seen some cases where it seemed like parents were really doing the best they could given their circumstances, what was going on psychologically, mentally, emotionally, addictions, that they were doing the best they could, possibly can do. And it just seemed like the system was working against them, you know, unfortunately.
Right.
You know, not in every case, but there's...
I agree 100%, and those are the areas that we oftentimes are frustrated with, the very, very strong drug addiction cases,
Right.
the mental health cases, and ultimately, getting back to AFSA, I think that that's really, as you said, the spirit of it is to try to look more at the children's interests in that circumstance and say, you know what, we've got to get these children placed, we've got to get them in a stable home so they have more opportunity to enjoy their childhood. And I think that's really where it comes from. So coming back to that, I think you're absolutely right. I think that that's the push, and that is the real drive behind AFSA, even though these are very tough cases, and those situations are very sad indeed.
So when we talk about this incentive piece, whether the primary focus is on family preservation, reunification, or is the primary focus on permanency or adoption, you know, in federal statute, federal law, there is provisions made for adoption incentives.
That's correct.
For money to be paid for adoptions. And what I saw, what did I see? I saw that 42 United States Circuit Court, I guess that's what the C stands for. Is that what USC?
USC, United States Code, actually.
Oh, United States. Well, I'm not an attorney, as you can see.
But that's all
United
right.
States Code 42.
I'm glad I knew it as well.
Well, that's great. Well, Statute 673B, as in boy, D as in Daniel 1, supports that states receive or awarded money based on the number of foster child adoptions. And that's regular foster care adoption, special needs adoption, and older child adoptions. And what I saw was like $4,000 for a foster child, $2,000 for, I don't know if that's $2,000 additional or for special needs adoption, but then also $4,000 for older children who are adopted. So this whole thing about incentive, is the incentive really to send folks home, or is the incentive more so let's get folk adopted?
Well, it's very interesting because I don't know, I can't comment really per se on how financially attractive that is. Maybe an adoption specialist otherwise could tell us about the costs of raising a child in foster care and whether that amount seems to be one that, as it's paid out, is one that really encourages it.
But that's to the agency, not to the private.
That's right.
Yeah.
And so when you're talking about the number of dollars or federal dollars coming in, clearly there are incentives therein. In reviewing that same section, or at least that general statute, there are other incentives, including, for example, if in fact there's a surplus in the pool, they may actually get additional monies for adoptions that occur in within a 24-month period. So there are all
Is there a contest going on that I don't know about?
Are you saying shortly thereafter a
This is
child is
tragic.
adopted within that first 2 years?
They're actually within the 2 years. So the shorter the time, there may be an incentive, assuming there's extra money available. That's what I was reading. But you're absolutely right. There are these federal funds that is in place to try to make adoption possible and to make it and facilitate it and make it happen. That is correct. That'd be my assessment of it as well.
Well, you know what? If you're listening to Fresh Start today, we're talking with attorney John Lamondola on in the courtroom with our special guest, attorney John Lamondola, and we're talking about understanding termination of parental rights and also the jury trial system in Wisconsin. I really want to kind of shift the conversation, start talking about the jury trial because we have about 20 minutes left. If you want to join this conversation, have a brief comment or question as relates to the topic we're discussing, please call 414-444-5250. So in Wisconsin, there is something called the jury trial system, and it's not constitutionally based, but more so statutorily based, meaning
That's right.
There's only 5 states in the U.S. who actually offer the jury trial. And so how does that connect to TPRs or a person coming into the child welfare system? Somebody called on my sister yesterday. She had her child removed. She has to go to court. What is the jury trial system?
So the jury trial system essentially is, first of all, it has to be initiated and engaged by a request. So
From who?
From the attorney or from the party, the necessary party. In this case, it would be the parent or his
The
attorney.
respondent.
The respondent.
Yes.
So at that initial appearance, from the time of the filing, there has to be an initial appearance in a 30-day period. That parent, after being advised of their rights and the court making a legal sufficiency finding to make sure that that petition is adequate, has to, one, decide whether they want to change a judge or not, and then ultimately make that request and preserve the 12-person jury.
Oh, okay, so that's the jury trial. So my child was removed. My sister's child was removed yesterday. I have a court case coming up. When is typically my first court
Okay.
appearance?
Now, in the case, the example you're giving, we're really kind of going back to the Child Protective Services case. Are you asking that? Or
yeah.
Okay, in those cases, exactly. We come in, the child's removed.
Yes.
There's a temporary physical hearing where the judge looks at the initial information to see if there's probable cause to detain. Then what they've been doing now to facilitate, make it process move a little faster is to file the petition at the detention hearing.
Wait a minute.
So
So
if the
when is the
parent is-
detention? When is the detention?
Yeah,
hearing?
the detention hearing is within a 72-hour period from
So
when the
within
child
3
is
days.
detained.
Okay. So now we have to show up at court
Yes, you'll get notice
within 3 days.
Yep, and the parent will be given a date and time to appear. Usually, the child welfare agency also has contact with the parent. They come to court where they're assigned or appointed an attorney if they qualify for one, and then they can make argument over the validity of that detention, whether the facts are sufficient for that detention or not, and as well as make other decisions and arguments about when should I be able to visit the child, where should the child be placed, whether there are any possible relatives, and then from that date they'll move out. They have been doing the initial appearance at that hearing if possible and the parent is present.
And if the parent is not present, they still file a petition
That's correct. They usually will file a petition if
to
they,
TPR.
Actually, no. At a detention hearing, we'll be moving to the Child Protective
To
Services.
the Child Protective
phase.
Service phase, which going to ongoing case management.
Right.
Okay.
And in those cases, it's very similar. We only have a right there to we only have, if we request it, a 6-person jury trial.
Okay.
5 of those 6 jurors would have to agree, or if the parties agree, we could waive and have a court trial to just have the judge hear the evidence.
But this is at that hearing within 72 hours that you are appointed an attorney. In
Yep.
72 hours, you're
That's
appointed attorney. And at this hearing, is that when you need to make the request
Yes.
for a jury trial?
Right.
And if you don't do it then, can you do it later?
Usually it's pretty loose, but technically you're supposed to request it. But I would clarify again, we're talking at the Child Protective
So Child Protection Service, right. Children are removed and are going into foster care.
Yeah, TPR, or termination of parental rights filings, usually come
After 15
much later.
Right,
Usually
15 months.
Not always, of course, but depending on the circumstances. But they typically come at a later phase. At that point in time, parent is personally served with a copy of the petition filed by the state, and they're given a date to appear. If they fail to appear, or do not cooperate with the process, they could be found in default, meaning decisions will be made without them, or they could lose their parental rights and probably would be found in default at that point.
So you have two tracks here. One is the bench trial track.
Yes.
And then you have the jury trial track.
That's right.
The bench trial track is where the judge is going to make the determination as to whether the child should go back home, or whether the state had the efficient, or the substantial grounds to remove that child and to keep them out of home care.
Right.
But a jury trial is when this person is tried by a panel of their peers to hear the evidence that's presented by the respondent and the petitioner being the state, to determine whether or not the state had the grounds to remove that child.
Right. In a CHIPS case, that's right.
In a CHIPS case, which is a child in need of protective services in CHIPS cases. So with that, the jury trial, I mean, I was reading something that noted that there was a legislative meeting that was held back in 2012, and there was a presentation to some folks that they wanted to get rid of the jury trial system because they felt that it was time consuming. They felt that there was a lot of work involved on the attorney side as well as on the case manager side. That was in 2012 here in the state of Wisconsin. And so what was found is that, no, it really does not take more time to go through a jury trial than a bench trial. But why do you think that the jury trial is an important or not an important aspect of the CHIPS cases?
Well, from a defense attorney's standpoint, one big reason is that and I'm not advocating one situation or the other. It depends on the case. Sometimes a court trial or a judge's trial would maybe be preferred. But from a logical standpoint, just a legal standpoint, we tend to err on the side of wanting a jury trial for one reason. In others, but particularly, one, you have to convince 10 of the 12 people in the termination of parental rights trial rather than merely a judge. Some of the drawbacks are, of course, that the judge is probably going to understand the legal aspects a little bit better. Judges hear a lot of these cases. They may not be as sensitive about some of the facts, although we have the flip side of that where jurors may be more sympathetic. So it really depends. It's kind of a toss-up. And I've read as well articles of the same nature, and the arguments on the other side are that there really are no particular statistical data to show that jury trials are more effective or less effective. But in any event, it's nice to have that option because there are cases where circumstances may bode better for the child. They may bode better for the parent. But again, it is a good thing that our state has kept it from a defense attorney standpoint.
I was reading something in the Wisconsin Law Review as it relates to the jury trial, and one of the advantages is that often in Wisconsin, the same judge who presided over a child welfare proceeding will also preside over the termination of parental right proceedings. Some critics of the use of jury trials in TPR cases argue that having a single judge hear all stages of a case increases the quality of decisions. However, this means that the judge knows information about the underlying child welfare case that would not be available to jurors, creating a risk of bias. Like ordinary people, judges are susceptible to a wide range of cognitive biases and operate at the biases that operate at a subconscious level. Jurors, on the other hand, according to the Wisconsin Law Review, what they reported, only have access to information presented at trial and are therefore less likely to be influenced by inadmissible facts. So when I'm looking at this, is it realistic to think that folks who work for government system, folks who work for legal system, folks who work for mental health systems, that bias can be a factor?
Well, I think it certainly can. As you pointed out, we're all human, and much of that depends on the discipline of the judge and the court hearing the case. Some judges are very good at applying just the facts to the elements, and they make a very, very good record at the closing of the evidence. And I think that's maybe one of the differences between a good judge in that situation and a judge who may allow himself or herself, unfortunately, to make that error. But in most cases, I think judges do try very hard to be very static or sterile in the evidence, rather than relying on information they may have had months before that may or may not even be relevant at that trial.
So in the jury trial has 2 stages.
That's correct.
And can you talk about what those stages are? Or?
Sure. The first part really is the jurisdictional phase in a CHIPS case or in a termination case. It's the grounds phase. And that's basically, let's put it as succinctly as possible, that's really about the parents' rights at that point. We have to get past that to determine whether the judge has the ability to either make a jurisdictional finding or, in a termination case, whether the parent is actually unfit or not. At the second phase, and the first phase is where we're talking about our jury trial rights or our court trial rights and the evidence, whether the state has proven its allegations. At the second phase is what we call the dispositional phase or the best interest phase. And at that point, the best interests of the child are the prevailing factors. So we're no longer as concerned about the parent. We're really now focusing on the benefits of the child at that point. So the parent's opportunity to really shine, so to speak, is at that first phase where they can litigate that first part of it to make sure that grounds are established.
But in litigating and trying to determine their fitness, whether or not they are a fit parent or not a fit parent, a lot of that can be based on the type of legal representation that they have. Would you agree or not agree with that statement?
I would agree. Much of it boils down to preparation.
Okay.
And, of course, trying to do an investigation and obtain as much positive information as you can about the client that you're allowed to present.
So if you're working with a client and you all are in the fitness stage, or you said in the parent's best interest, in the parent's interest stage, in the parental interest stage, what are some of the conversational things that you would do with your client if I were your client?
Well, the first thing we would try to determine, let's use one quick example in terms of probably the most commonly filed petition, and that is the allegation of continuing need. I would try to establish through documentation this client's level of participation and completion of services. I would go back to the file we're provided with discovery and go through that file and try to determine the number of contacts and visits that parent has had and establish the relationship that they have. And then we will turn around and try to have providers come to court if we believe they're going to be positive witnesses.
So that might be the therapist. That may be certificates from a parenting or nurturing class.
Exactly.
Visitation worker notes and
That's
things
right.
like that. Okay.
Let's say they haven't quite, let's say we have to concede that we haven't met the conditions. Well, they have a 9-month period if they can show they're substantially likely to make those to meet the conditions. And so what we try to do is we try to show their past performance as being constructive, and then we try to show that they are on track or that they can meet these conditions in the 9 months to follow.
So I'm thinking, you're representing me, and you're advising me that I really need to go to these classes. I need to go. I need to participate in supervised visits. And what if that relationship is not going well? Because there are times when folks can call an attorney, they're swamped, they're busy, and the attorney can't get back with them. You feeling like you just really, you can't get the service that you're looking for. Is there a mediation or grievance process that a client and their attorney can go through to try to resolve those issues, just so that parent can get the best legal representation? I know we have a caller. Caller, if you can hold on for a few seconds, and we'll be taking your call shortly.
One of probably the immediate actions that's taken is a request for another lawyer. And so you can address that with the court, or you can contact the lawyer and say, maybe we're just not working well together. Mm-hmm. Maybe you're too busy. But at some point, I would like you to not continue representing me. I would like you to ask the judge if I could be assigned another lawyer. That lawyer will, in turn, pass that on and file a request to withdraw as attorney. That's probably the most common way of dealing with it.
What if I don't like the judge? That's all my case. Do I have the grounds to request that we move Judge Wapner from the bench?
Well, short of some major malfeasance, no. Once you enter a plea, you cannot change judges in the future.
Once you enter a plea, at what point did I make my plea? Was that within 72 hours?
That was at the initial appearance.
I just met you, my attorney, as well, at this initial hearing. So I don't know you from Adam, but you're going to represent me. And would you tell me that who will tell me that I have an option for a jury trial?
Well, I think, let me clarify real quick. One of the things they are doing is filing the petition at the initial appearance in a child protective service case. They usually will give us an initial appearance date. If the client is prepared or the parties want to try to enter stipulations, agreements, or some other kind of entry of a plea, they can do that. The judge reads them all of their procedural rights at that phase, at the initial appearance. So I didn't mean to give the impression that we're trying to get everything done at the first hearing, but there is, at least the filing is made early on.
My plea, and that plea is big.
That's big because
That's huge.
Once you enter a denial,
You
preserving your rights, unless you have filed or had your attorney request.
But how would I know that I want Judge Wapner to be removed from my case within 72 hours?
Right.
I mean, I haven't.
Right, and if they
I didn't realize I didn't like him until the third court appearance.
Right.
But it's too late. Now I got to deal with him.
And again, as I say, giving the court system the benefit of the doubt, we usually do have a secondary date, which will go out a few weeks. But you're absolutely right. You're going to have limited exposure. You're relying much so on the attorney to say, this is the kind of judge that I think we have. We can recommend it, but it's not our decision.
How long do those initial hearings normally last?
Initial appearances quite fast. Now, when they call the case, it's another story. I mean, if you could be there for quite a while.
But when we're actually in the courtroom.
Maybe 15 minutes.
Oh, my God. Caller, you're on Fresh Start today. You have a brief question or comment?
Yes, you are actually on point. Because of my experience with dealing with parents, they don't understand that stuff.
Yes,
and
ma'am.
so they don't know that the person who's represented them these are poor parents I'm talking about. They don't know that the people who are representing them don't really know about their case. Not really, because they are so swamped with, overloaded with stuff. And you are asking the good questions because this is what is the problem with what's going on with our black parents, who have to rely on those the people who are inexperienced, with this.
And it's frustrating.
It's frustrating, and when I was dealing with this, it was just really so frustrating. And so you are asking the right questions because this is. They've tried to act like that you're so represented, but you're really not represented, and the parents don't know what kind of questions to ask. You see what I'm saying?
Exactly. I think there needs to be a training. And that's one reason why, caller, that we have this program is to educate the community about what goes on in the court, who is who in the courtroom, who are the players, what are your rights, because a lot of us don't know this kind of stuff. And unfortunately, it's the neighborhoods that this radio program is broadcast in have the highest detention rates in the state. And we do know.
They take their kids away, and they don't necessarily want their kids to be taken away.
You're right. And people need to understand that 67% of the Bureau, it's no longer the Bureau of Milwaukee Child Welfare. The Bureau of Milwaukee Child Welfare has changed their name. They are now the Division of Milwaukee Child Protective Services. The Division of Milwaukee Child Protective Services. 67% of the families and children who are the clients of the Division of Milwaukee Child Protective Services, according to the Department of Children and Families annual 2013 report, 67%. And so when we talk about child welfare reform, we have to really look at what is the administrative, executive, or the division plan to reduce the number of African American children and families who are served by this agency. Now, you almost need to understand that there is the Bureau Director's position, the former Bureau Director's position, which is now the division. They look for a division administrator. You all need to get in contact with your senators and your legislators, the legislative folk, and kind of talk about, what you all are looking for in the division administrator. Because if we want to really do child welfare reform, let's reduce 67%, whether that's 67% Latino, 67% Caucasian, 67% Asian, 67% African American. If we really want to see significant change, let's get that number down. Thank you for calling.
Right.
Now, we only have a few more minutes, and I appreciate Attorney John LaMendola. Now, do you represent people private? Because all this stuff is good, but you got to have, some folk feel like you got to have money, hire a private attorney to get quality representation. Do you see a difference? Let's use a national lens here. Do you see a difference in the type of representation folks receive if they pay for an attorney versus if one is appointed by the courts because they don't have the financial means?
Well, it's a very good question, and I think much of that depends on the attorney, him or herself. I think I dedicate, even though I'm appointed in most cases to represent folks in these cases, I still pour my heart and soul into them. They're very important cases.
Right.
But I will grant you that there is severe underfunding in both the public defender as well as the county for compensation. So one of the problems is, do we really attract the most experienced attorneys
With the pay.
with the compensations being offered? I know.
Well,
many
let me say
attorneys-
some stuff. I ain't gonna let you put yourself out there. Let me put myself out there. So basically, if someone who has expertise in a certain area and they're good at their craft, you know, if I want to have them represented on a case, a CHIPS case, but the government is only paying some pennies, nickels, and dimes for me to represent this family, what is the motivation there for me to take on these cases? And some folk are really good. I've seen some great attorneys. I've seen some not so great attorneys. But if the pay was more, you get what you pay for at the end of the day.
I think you attract a larger body of qualified people as well. It can only help. As for those of us who do it and continue to do it, it's a dedication that we have. It's a field that we're good at. We like it. I believe most of us are doing it for the right reasons, and it is a tough field. There's no question about it. We're dealing with some of the saddest cases. So it takes a real commitment. But
can folks hire you if they have some means,
actually,
or if I have to go out here and wash some cars and do it because my parental rights
that's
is
true.
very important. We had a lady here back in November whose son was removed. He was gone for 6 months, but she hired an attorney. She was not in a financial place to do that. She took on a huge debt, but her parental rights were worth it.
Yeah, you certainly can retain your own attorney. I would advise, obviously, as with any legal advice you're seeking, to make sure they have a great deal of experience in the field. Can folks hire you? They certainly can.
And how can they reach you?
You can call my office number. It's area code 414-762-6028. Again, 762-6028. Attorney John Lamondola.
And let me close by saying that every child that's in the child welfare system is not there just because the government came in and they didn't want us to have our kids. There's some children who actually needed some type of government intervention. But this conversation is around those folks who, you know, you're innocent, you didn't neglect, you didn't abuse your child, and somehow somebody called in and they came in and removed your child, what you should do. So hopefully we can have Attorney John Lamondola.
Yes, sir. Yes,
come
sir.
back on the show in the future.
Anytime. I really appreciate the offer, and I'd be more than happy to come back on other issues.
Sounds great. Next week, we're going to be talking about fire safety and then also an update from the Fatherhood Initiative, and particularly about fathers' relationship with child welfare. Thank you for tuning into Fresh Start today. Be well and be safe.